Good afternoon, you may be seated. Calling the case of People versus Samantha Rose Addison, file 20-10581-PH, with counsel identified for the record, please.
Good afternoon, Your Honor. Norman Gage, attorney on behalf of the prosecutor's office. Your Honor, if I may, before we get started, I'd like to wish my good friend and esteemed colleague, Mr. Wilford, a very happy birthday today.
Oh, well, congratulations, Mr. Wilford.
Thank you, Judge.
Happy birthday to you.
Louis J. Wilford, 127 North Arcade Street, Glen, Michigan, representing Ms. Pettis.
Ms. Panasak, would you please stand and raise your right hand and be sworn in?
Do you solemnly swear testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Could you tell us your name?
Samantha Rose Pazak.
You may be seated if you'd like, Ms. Panasak. Ms. Panasak, have you received a copy of the information charging you with count 1, uttering and publishing?
Yes.
Do you want me to read that information to you?
No.
Do you want to have a preliminary examination?
No.
Do you understand, ma'am, that according to count 1, you are being charged with the crime commonly known as uttering and publishing?
Yes.
Now, that crime is a felony, and it carries a maximum penalty of 14 years in prison, and the minimum sentence is discretionary with the court. Do you understand those things, miss?
Yes.
Now, you may make any one of the following 3 pleas to count 1. First, you may plead guilty if you are guilty, but don't plead guilty unless you are guilty. Second, you may plead not guilty. And third, you may stand mute and say nothing, in which event the court would enter a plea of not guilty for you. Do you understand the 3 possible pleas that you may make to count 1, uttering and publishing?
Yes.
Then answering to count 1, uttering and publishing, what is your plea?
Guilty.
Now, ma'am, do you understand that no one can make any promises for me about what your sentence will be?
Yes.
The court also informs you that if your plea of guilty is accepted, then that means you won't have a trial of any kind, and you therefore would be giving up each and every one of the following rights. The right to have a trial by a jury, the right to have a trial by a judge sitting without a jury if you prefer, the right to be presumed innocent until proven guilty, the right to require that the prosecutor prove you guilty beyond a reasonable doubt, the right to have all of the witnesses against you to appear at the trial, and for you and your lawyer to have the chance to question and cross-examine those witnesses, the right to have this court order any witnesses that you might want for your defense to be required to appear at the trial, the right to remain silent during the trial and to not have your silence used against you. But finally, you also do have the right to testify at the trial. And if you choose to do so, then your testimony would be considered in the same manner as the testimony of any other witness. Now, do you understand all of these rights, miss?
Yes.
And do you understand that by pleading guilty to count 1, that means you'll be giving up each and every one of those rights?
Yes.
Well, I'm going to ask your lawyer, Mr. Wilford, and the chief assistant prosecuting attorney, Mr. Gage, to tell us what the plea agreement is, and I want you to listen to both of them very carefully. Mr. Gage, what is the plea agreement?
Your Honor, in return for the defendant's guilty plea to count one, uttering and publishing, upon the court's acceptance of that plea, pronouncing sentence, and running the appropriate appeals period, count 2 and 3 would be dismissed. Restitution would be assigned appropriate by the court for all matters raised in this case.
It is the court's understanding the defendant will be applying for youthful trainee status. Do the people deserve the right either to support or to oppose that petition?
We do, Your Honor.
Mr. Wilford, is that your full and complete understanding of the plea agreement?
Yes, it is, Your Honor.
Ms. Patizak, did you hear what the prosecutor and your lawyer said the plea agreement is?
Yes, I did.
Did you understand the plea agreement?
Yes, I
And do you agree with it?
did. Yes.
Has anyone promised you anything beyond what is in that plea agreement to get you to plead guilty?
No.
For example, has anyone promised you that if you pled guilty, that this court then would be lenient or light on you in any way?
No.
Has anyone threatened you or threatened your family to get you to plead guilty?
No.
Is it your own personal choice to plead guilty, and are you doing so freely and voluntarily?
Yes.
Now, do you have any questions about what the court has told you?
No.
Do you understand everything that the court has told you?
Yes.
In light of everything that the court has told you, do you still want to plead guilty to count one?
Yes.
Then, Miss, drawing your attention back to on or about July 27 of 2020, were you in Sherman Township in Gladwin County, Michigan?
Yes.
On that day and at that location, did you write out a check and present a check made payable in the amount of $400 and drawn on Members First Credit Union and dated July 27, 2020, and listing as the drawer or maker Thelma White?
Yes.
And this was a forged check, is that true?
Yes.
And did you somehow cash this forged check?
I did.
Where did you cash it, Miss?
In the ATM?
Okay, so you wrote out this check for $400. It was drawn on Thelma White's account, is that true?
Yes.
And you put yourself, Samantha Patizak, down as being the payee, the person to whom the money was to be paid?
Yes.
And that you deposited that $400 check through the ATM into your own checking or savings account?
Yes.
Now, did you have any permission from Thelma White to sign her name to this document?
No, I did not.
And did you have any permission from anybody else?
No.
At the point in time when you did these things back on July 27, were you intending to defraud Thelma White and to get this money illegally?
Yes.
Are you satisfied, Mr. Wilford, that there is a sufficient factual basis to accept the plea of guilty?
Yes, Your Honor.
Do you agree, Mr. Gage?
I agree, Your Honor.
Mr. Wilford, has the court complied with the court rule in the taking of the plea?
The court has complied with the court rule, Your Honor.
Do you agree, Mr. Gage?
I do, Your Honor.
Your Honor, This Pedestack is going to be applying for consideration under the Home Youth Trainee Act. I will go back to your office and have her sign the petitions for that and return it to you.
Thank you, Mr. Wilford. Very well, then, in this case, the court has not agreed upon the possible plea or the possible sentence which the prosecutor, the defendant, the defense attorney, or anyone else. The court is convinced that the plea is accurate and has been understandingly, knowingly, and voluntarily made. The plea of guilty is accepted and ordered entered on the records of the court. Sentencing will occur on Monday, November 23rd. Sentencing and/or disposition under the Holmes Youthful Trainee Act will occur on Monday, November 23rd, 2020 at 1 p.m. Bond is continued and the case is adjourned to the date and time indicated. But before you leave here, Ms. Patasak, when you come back on November 23rd, you could be sent to prison for up to 14 years, or you could be put in county jail for up to a year, or something else might happen. But one thing that will happen is you'll be ordered to pay some court-ordered money that will add up to probably $2,400 or $2,500 or more. So you now have another month to take legal steps to raise that money and have it available to you at the time of the sentencing. Before you leave here today, make sure you speak to Agent Greg Brady from the Lateran County Circuit Court Probation. Thank you, Miss. I'll continue the bond, and we'll see you back here on November 23rd.
Thank you, Your Honor.
Thank you, Mr. Wilford. Thank you, Mr. Gage. Thank you. Greg, when you get back, could you stop back in chambers when you have a moment?
Yes, sir.
We'll be in recess.
All right.
I don't know, Doug Emerson said give it to you. There you go.
Happy birthday, Jake.
Thank you. Today was also President Eisenhower's birthday.
Yeah. Two of my favorites.
He would have been 130 today.
Oh, shoot.
Just a couple years older than you, Jay.
Yeah, not bad at all.
This is a big one, isn't it, Jake?
80.
Yes.
Is this your 80th? Well, happy
Yeah.
80th birthday.
Hey, Jake, have a good day.
You tell the family to take you to Lucky's tonight, Jake. 80 years old. Could you imagine?
Well,
Yeah.
it's
I'm gonna
getting
get my rocking
easier
chair.
all the time.
At 80, I'm gonna be at home, crocheting a little blanket. I'm not gonna be working, I can tell you that.
Veteran is back in session. The Honorable Thomas R. Evans presides.
Good afternoon, you may be seated. Calling the case of People versus Richard Leroy Davis, file 20-10577-FC. Would counsel identify for the record, please?
Good afternoon, Your Honor, Norman E. Gage, attorney of the prosecutor's office.
And I'm attorney Rebecca Kreischer for Mr. Davis.
Mr. Davis, would you please stand and raise your right hand to be sworn, sir?
Yes, sir.
Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir. Yes,
Could
sir.
you tell us your name?
Name is Richard Leroy Davis.
You may be seated if you'd like, sir. Today is the date and time scheduled for the arraignment in this case. How did you want to proceed, Ms. Kreischer?
Well,
Mr.
I'm
Davis, may I?
The question was directed to your lawyer, Mr. Davis. How did you want to proceed, Ms. Kreischer?
I just met with Mr. Davis at the jail. We request a remand to district court in order to conduct the preliminary examination.
All right, are you sure that's what you want to do, sir?
Well, yes, sir, because there's some errors here.
All right, well, the whole point of a preliminary examination is not necessary, or even a criminal prosecution is not necessarily to sort out all the errors. The point of the prosecution is whether there's proof beyond a reasonable doubt that you committed the crimes with which you are charged. But in any event, you've asked to have the case remanded back to district court. Apparently, you think that's in your best interest for some unknown reason. Do you have any objection, Mr. Gage?
I have no objection, Your Honor, but let it be clear to Mr. Gates, the plea offer is out there no longer exists.
All right. The plea offer has been withdrawn, Mr. Davis, and the case will be remanded back to district court. And I hope this is not one of those cases where, as the old admonition goes, be careful what you wish for, because you just might get it. In this case, you have gotten what you wished for. The case is remanded back to district court. The plea offer has been withdrawn, and good luck to you. Bond status is continued. Miss, could you tell us your name? Thank you, ma'am. Calling the case of People versus Regina Colleen Humphrey, file 20-010546-FH. Would counsel identify for the record, please?
Good afternoon, Your Honor. Norman E. Gage, appearing on behalf of prosecutor's office.
And I am attorney Rebecca Kreischer for Ms. Pumphrey.
And Miss, are you Regina Pumphrey?
Yes, sir.
Previously, Ms. Pumphrey, back on September 14 of 2020, you appeared in court, and at that time you pled guilty to the 5-year felony crime commonly known as attempted possession of methamphetamine. You appear here today to be sentenced. The maximum penalty the court could impose is 5 years in prison. The minimum sentence is discretionary with the court. In the Gladwin County Circuit Court Probation Department and the Michigan Department of Corrections have prepared a pre-sentence investigation report as well as a sentencing information report. And in those two reports, at least thus far, they calculate your applicable sentencing guideline range to be 0 to 3 months in jail. Although pursuant to People versus Lockridge, those guidelines now are advisory instead of mandatory. Ms. Kreischer, have you reviewed both of those reports with your client?
Yes, I have, Your Honor.
Is there anything of a factual nature in either report that you want to add to or explain or contradict?
Yes, Your Honor. In terms of jail credit, Ms. Pumphrey has been lodged since October 5th till today. According to my calculations, that would be 9 additional days of credit for a total of 16. That's on CFJ-101, about halfway through, CFJ-145 at the top, and page 1, and CFJ-145, page 2 at the top.
No objection to that change, Your Honor.
Very well, the court will make changes in the three places specified and direct the department to do so as well as anywhere else in the report where it would be appropriate. Is there anything else in either report of a factual nature you want to add to explain and contradict, Ms. Fleischer?
No, Your Honor.
Do you have any challenges to the scoring of the prior record variables or the offense variables, or any challenge to the guidelines as scored at 0 to 3 months?
No, Your Honor.
Mr. Gage, on behalf of the people, I would pose that same series of questions to you.
Your Honor, I've had the opportunity to review precinct's investigation report with the noted change for 2 days jail credit. I would ask the court for new additions, corrections, or deletions. I've run the scoring guidelines. I believe the prior record variable and offensive variables are properly scored, and the recommendation based on that is appropriate. So we're asking for changes there.
Thank you, sir. Ms. Pumphrey, is there anything you want to say on your own behalf, ma'am, before the court passes sentence?
No, sir.
And on behalf of your client, Ms. Fleischer?
Ms. Pumphrey does not have an adult criminal history. She did have some issues when she was a juvenile, and that was over 13 years ago. She is in jail currently because she was surrendered by her bondsman for failing to test as ordered as part of the pretrial release conditions. She advised me that she was having monetary problems and was unable to pay for all the testing. I have had conversations with her, and she has stated she is willing to do outpatient work and other steps in order to address her substance abuse issue. She does have children, and she wants to be the best parent possible. The sentence guidelines are 0 to 3 months. We respectfully ask for a sentence of time served and probation for 2 years. Thank you.
Thank you, ma'am. And on behalf of the people, Mr. Gage?
Your Honor, in this matter, the defendant is a drug addict. During the time that she was out on bond, she tested several times for using controlled substances, and she quit doing her testing because she said it was a cost factor. Didn't buy to clear that before everything, she just made a decision unilaterally. So numerous violations of terms and conditions were done. The statutes allow for the court to grant 7411 status, and the statute also allows that you can deny it based on her failure to comply with bond conditions. In this case, she demonstrated repeatedly that she's not ready to deal with her substance abuse issues. She demonstrated repeatedly that if the court puts her on probation, the 7411 requires her to do drug testing, what the decision is going to be. So I'm going to ask the court to deny status under 7411. I'm going to ask the court to place her on 2 years probation, and then ask the court to place her in jail for a minimum of 60 days. I think that addresses, one, the nature of the crime that she committed, holds her accountable. Methamphetamine is a dangerous drug, and she's using it on a regular basis. So if we're going to test for positive on amphetamines and traces of methamphetamine. So the problem is there, and continues. So for those reasons, Your Honor, I ask the court to deny 7411 since for period of probation with not less than 60 days of jail confinement.
Thank you, sir. Very well, Ms. Pumphrey. You've dug a hole for yourself by your behavior or through your behavior while you've been out on bond, and you certainly are using bad judgment up until this point. It's the sentence of the court. You'll be placed on probation for a period of 2 years. Now, in addition to all of the statutory terms of probation, you also must abide by all the written terms of your probation order as well, which include but are not limited to: you must not use or possess any alcohol or controlled substances, or drug paraphernalia. You must submit to drug and alcohol testing on demand, and you must successfully complete any substance abuse treatment program to which you are referred by the probation agent, and give up any confidentiality right you have in any such program so that the court may monitor your progress. You must seek and maintain full-time employment and/or be enrolled in a full-time education program. You must not have any contact with anyone whom you know to have a felony record unless you first get written permission to do so from the probation agent, and you must not possess any weapons or copies of weapons. You must not engage in any assaultive, abusive, threatening, or intimidating behavior, and you must submit to a search of your person and property without the need of a search warrant. Further, the probation agent does have the legal right to arrest you if he has reason to believe you have violated your probation, or even merely reason to believe that you are conducting yourself in a manner inconsistent with the public good. You must comply with DNA testing and pay a $60 fee for that purpose, and you must pay $68 in state costs and a crime victims assessment of $130, a supervision fee of at least $30 per month, rising to $60 per month for any time period when you are supervised on electronic monitoring. You must pay court costs of $500 and a fine of $500, and court-appointed attorney fees of
$690.
Thank you, Ms. Kreischer. Court-appointed attorney fees of $690. How much of that approximately $2,300 do you have available today to pay towards your court-ordered money? Ms. Pumphrey, any of it or not?
I think I paid $175. It's in an account at the county clerk's.
All right.
Close to county clerk, but I'm in jail, so.
Okay, thank you, miss. Then you must pay $175 today and at least $100 per month to be paid by the first day of each month, starting on December 1st, 2020, with an additional $100 payment due by 12 noon on the first day of each month after that until paid in full, but it all must be paid by the time you get off of probation. Then I have to decide whether to put you in the county jail or not. The prosecutor has pointed out you were given a chance while you were on bond to show that you could follow a few simple rules, and apparently you could not do that. So he suggests that I give you, I believe it was at least 60 days in jail, and the guidelines would permit up to 90 days in jail. And the law would permit that I sentence you to up to 5 years in prison. What I'm going to do is this. I'll sentence you to serve 16 days in the Gladwin County Jail. I'll give you credit for the 16 days served. The final decision I have to make is whether or not to grant you this special status under the 7411 statute. If I don't do that, you will be a convicted felon. If that happens, you will lose some of your constitutional rights. You will lose your right to vote for a period of time. You'll lose your constitutional right to keep and bear arms essentially forever. And you'd find it very, very hard to get a job in the future And one of the smallest but inconvenient things that would happen is your driver's license, if you have one, would be revoked or suspended. I'm going to grant you the 7411 status. I'll give you the chance to keep this felony conviction off your record. But it's going to be up to you whether or not you keep that status or not. And I certainly hope you're able to follow the rules while you're on probation. Because I've granted you the 7411 status, there's no need to advise you of any appellate rights because they don't get attached, because I have not imposed a final sentence yet. The bond is canceled and any bond posted in your own name will be applied towards the court-ordered monies. Good luck to you, Ms. Humphrey. Anything further, Ms. Fleischer?
No, Your Honor, thank you.
Or Mr. Gage?
No, Your Honor.
Very well, thank you, Ms. Pumphrey. Good luck to you, ma'am.
Thank you.
You're welcome, Ms. -10543-FC. Would counsel identify for the record, please?
Good afternoon, Your Honor. Norman E. Gage, appearing on behalf of the prosecutor's office.
Good afternoon, Your Honor. Karen Tomczyk appearing on behalf of Mr. Sanders.
And are you Michael John Blanchard Sanders?
Yes, Your Honor.
Previously, Mr. Sanders, back on September 14th of 2020, you appeared in court. At that time, you pled guilty to the one-year misdemeanor crime of domestic violence, second offense, and also pled guilty to the 7.5-year felony crime of assault with intent to do, attempted assault with intent to do great bodily harm less than murder, and habitual offender second offense notice. You appeared here today to be sentenced. Now, attempted assault with intent to do great bodily harm less than murder or attempted assault by strangulation is a felony and ordinarily would carry a maximum penalty of 5 years in prison, and the minimum sentence would be discretionary with the court. However, because you also pled guilty to being a habitual offender, second offense notice, the net effect of that is that the court, in its discretion, could raise the maximum penalty for the felony from 5 years in prison to 7.5 years in prison. It would be discretionary with the court whether or not to raise the maximum end of the sentence. And regardless of whether the court does so, the minimum end of the sentence is discretionary with the court. Do you understand those things, Mr. Sanders?
Yes, Your Honor.
The Gladwin County Circuit Court Probation Department and the Michigan Department of Corrections has prepared both a pre-sentence investigation report as well as a sentencing information report. And in those two reports, at least thus far, they calculate the applicable sentencing guideline range for the felony to be 5 to 28 months, although pursuant to People versus Lockridge, those guidelines now are advisory instead of mandatory, and there are no sentencing guidelines for the misdemeanor conviction. The court has reviewed the two reports, and it appears that two small corrections for typographical errors should be made. First, on page 1 of the CFJ 101, the face sheet of the entire packet, about halfway down the page under the heading current offense, It indicates number 1 of 2, domestic violence and/or assault on a pregnant individual, second. And then in parentheses, have criminal second offense. And the court believes it to be appropriate to strike the entry in the parentheses because the habitual offender does not apply to the misdemeanor. And then immediately to the right of that entry, it indicates the maximum offense being 1 year, 6 months. The court believes the maximum should be 1 year, and to strike the 6 months entry. Then 2 pages later, on page 1 of the CFJ 145, under the heading current convictions, the court would suggest making the same 2 corrections with regard to charge 1, the domestic violence misdemeanor conviction. Is there any objection to those things, Mr. Gage?
No, Your Honor, I believe they're appropriate.
Or Ms. Tomczyk?
No, Your Honor.
Very well, the court will make those changes and ask the department to do so on the original of their reports as well. Ms. Tomczyk, have you gone over both of these reports with your client?
I have, Your Honor.
Is there anything in either report of a factual nature that you want to add to or explain or contradict?
No, Your Honor.
Do you have any challenges to the scoring of the prior record variables or the offense variables or the calculation as to the applicable sentencing guideline range being 5 to 28 months?
No, Your Honor.
Mr. Gage, on behalf of the people, I pose the same series of questions to you.
Your Honor, I've had the opportunity to review the precinct's investigation report. I noted the same changes the court's already addressed. Other than that, I have no other additions, corrections, or deletions that I would ask the court to consider making. With regard to the prior record variable, I believe it's sort of appropriate with the offense variable is sort of appropriately the recommendation based on that is appropriate.
Thank you, sir. Mr. Sanders, is there anything you want to say on your own behalf, sir, before the court passes sentence?
Yes, Your Honor. I'm sorry for what I did. I shouldn't have did what I did to her. I got a daughter. I got a 3-year-old. I want to be able to see her. And I've been trying to stay out of trouble, but I lost her because she cheated on me. I'm sorry. I wish I could never. I wish I didn't do it.
Thank you, sir. And on behalf of your client, Ms. Tomczyk?
Yes, Your Honor. Obviously, as the court can see through Mr. Sanders' statements here today and the pre-sentence investigation report, Mr. Sanders has shown remorse for what he's done, Your Honor. And in speaking with Mr. Sanders, we believe that the recommendation from the Department of 6 months is a fair recommendation and ask that the court adopt that recommendation.
Thank you, ma'am. The record should reflect that the court has been conducting this sentencing via Zoom. The Chief Assistant Prosecuting Attorney is present here in the courtroom physically, as am I, and the defendant is physically present at the Gladwin County Jail, participating via Zoom, and the defense attorney, Ms. Tomczyk, is at her office participating via Zoom, and that is pursuant to Michigan Supreme Court Administrative Order 2020-9. Is that procedure acceptable to you, Mr. Gage?
It is.
And to you, Ms. Tomczyk?
It is, Your Honor.
Thank you, Ms. Are there any victims present who wish to speak to the issue of sentencing? Specifically, Joanne Dufresne.
I'm here.
You are present via Zoom. You don't have to, miss, but did you want to say anything regarding sentencing, ma'am, or not?
I already talked to him about it. I feel like I don't want to see him go back to prison.
Okay, thank you, ma'am. And on behalf of the people, Mr. Gage?
Your Honor, this.
Oh, I'm sorry, Mr. Gage. Miss, could you tell us your name?
Joanne Dufresne.
Thank you, Mr. Gage, I'm sorry. Would you, on behalf of the people, like to say anything?
I would, Your Honor, thank you. Your Honor, this is the defendant's third go-around with an assaultive type nature. He had a domestic violence charge in 2013. He pled guilty to it. He had a domestic violence charge in 2014, of which he pled guilty to disorderly conduct. Court placed him on probation for 12 months at that point in time. In the year 2020, visiting the same issues again. But he investigated how to choke people. What we have is a demonstration of this is the failure of the probation department to make changes in people's lives because they don't want to change. The guidelines are 5 to 28 months in court records that are sent into prison for a period of time because they can't assault anybody there.
Thank you, sir. Well, first, I don't see this as an abysmal failure on the part of the probation department. I see it perhaps as an abysmal failure on the part of the defendant. But as Mr. Grady was pointing out to me not too long ago, the probation department basically is at the end of a long line of other entities that in large part have already failed. It's not always the case, but it's often the case that the defendants have failed in, or the schools, if you will, have, quote, failed, unquote, in dealing with the defendant. And then the police have, quote, failed in dealing with the defendant. And the prosecution and the courts have, quote, failed in dealing with the defendant. And then the problem, if you will, the defendant is turned over to the probation department with the instructions, well, fix them. And lo and behold, they're not able to fix them. Mr. Sanders, I don't mean to speak of you as if you're not here or not participating in this process. And certainly not all hope is lost because hope springs eternal in the human breast. And
Excuse me, Your Honor, can I say something?
You may if you would like, sir. What's that, sir?
I turned myself in on these cases so I could fix myself, so I can get help. I got a daughter, I got a 3-year-old. I've been trying to stay out of trouble for 7 years. I got off parole in 2013. I've been doing good. I successfully completed 2 probations. I didn't mean to do what I did. I want to see my daughter grow up. I don't want to go back to prison for the rest of my life.
Thank you, sir. I believe you. And I hope that you are able to follow through on your good intentions. The prosecutor touched on this a little bit, but this is a situation where you choked your significant other. And I can tell you, I'm not a physician, but I can tell you this, it's easy to kill someone when you choke them. And it's easy to inadvertently kill someone when you choke them. And it's even possible to choke someone and to release the pressure on their neck and have them still die from the compression to their veins and arteries. So this is not something the court takes lightly. If any of those things had caused this lady to die, you would be going to prison probably for the rest of your life. Now, I understand you were very upset. I understand you said she cheated on you. But like it or not, we don't get to physically attack people just because they hurt us or they betray us. You know, you're not acting in self-defense when you do those things.
I know, I do anything, Your Honor. I go on mental health, I get anything. I do 5 years probation. I wanna see my daughter grow up. I haven't been away from my daughter in 3 years. I'm not a deadbeat dad. I just
All right,
messed
no one has-
so
Just a moment, sir. No one has accused you of being a deadbeat dad. And I don't mean to cut you off, but you were given your chance to speak earlier and you took advantage of it, as you should. Now, in order to punish you for what you've done and to deter you and others from committing crimes in the future, I'm not going to sentence you to prison today, but I am going to put you on probation for 2 years. In addition to all of the statutory terms of probation, you must abide by all the written terms of your probation order also, which include but are not limited to, you must not use or possess any alcohol or controlled substances or drug paraphernalia. You must submit to alcohol and drug testing on demand, and you must give up any confidentiality. You must successfully complete any substance abuse treatment program or alternatives to violence treatment program to which you are referred, and give up any confidentiality right you have in any such program so that the court may monitor your progress. You must not engage in any assaultive, abusive, threatening, or intimidating behavior, and you must not possess any weapons or copies of weapons. You must not have any contact with anyone whom you know to have a felony record unless you first get written permission to do so from the probation agent. You must seek and maintain full-time employment and or be enrolled in a full-time education program. You must submit to a search of your person and property without the need of a search warrant. And the probation agent does have the legal right to arrest you if he has reason to believe you have violated your probation, or even merely reason to believe you are conducting yourself in a manner inconsistent with the public good. You must comply with DNA testing and pay a $60 fee. For that purpose, you must pay $118 in state costs and a crime victims assessment of $130. You must pay a supervision fee of at least $30 per month, going up to $60 per month for any time during which you are supervised on electronic monitoring. You must pay court costs of $500, a fine of $500, and court-appointed attorney fees of, do you have an estimate, Ms. Township?
$560.
And court-appointed attorney fees of $560, all to be paid at the rate of no less than $125 per month, with the first payment due within 30 days of your release from jail, and similar payments of at least $125 due each month after that until paid in full, but it all must be paid before you get off probation. Finally, you must serve 6 months in the Gladwin County Jail, but you will receive credit for the 56 days you've already served. Mr. Sanders, it's my duty to inform you, sir, that you are entitled to appellate review of your conviction and sentence. And if you are financially unable to hire a lawyer, then the court will appoint a lawyer for you and will furnish that lawyer with the records and the transcripts that are necessary to perfect an appeal. but a request for the appointment of an attorney must be made within 42 days of today's date in writing and sent directly to the court. Bond is canceled, any bond posted in the defendant's own name will be applied towards forwarded monies, and the defendant is remanded to the custody of the sheriff for the carrying out of the sentence. Good luck to you, sir. Oh, and the clerk is pointing out the sentence or questioning, the sentence I just gave you, sir, I've put you on probation both for the felony and the misdemeanor. The terms of that probation are identical to one another. The two-year probationary periods will run concurrently to one another. And I'm sentencing you to 6 months in the county jail for the misdemeanor conviction with credit for 56 days served, and 6 months in the Gladwin County Jail with credit for 56 days served for the felony conviction. And the 2 jail sentences, as well as the 2 probationary periods, will run concurrently to one another. They will run at the same time. Good luck to you, sir. Thank you. Anything else, Ms. Thompson?
No, Your Honor, I believe that takes care of all my cases.
Or Mr. Gage?
No, Your Honor.
Then we'll be in recess. Thank you both, and thank you, Mr. Sanders.
Thank you, Your Honor.
Are you ready on your matter, Mr. Santini?
Is Mr. Greg dialed in? Oh, yeah.
It appears he is.
Very well. Calling the case of People versus Garrett Norman Grigg, file 20-010567-FC. Would counsel identify for the record, please?
Good afternoon, Your Honor. Review of the prosecutor's office.
Thank you, Your Honor. Andrew Santini on behalf of Mr. Gregg.
And Mr. Grigg, would you please stand and raise your right hand to be sworn, sir?
Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I couldn't hear you, sir.
I swear.
Thank you, sir. You may be seated. Could you tell us your name?
Garrett Grigg.
Mr. Grigg, have you received a copy of the information charging you with count 1, obstruction of justice?
No.
Have you reviewed the information with your lawyer?
No, I haven't got to talk to my lawyer before this.
All right, well, we'll take a break then and let you speak privately with your lawyer. Then we'll go ahead with the arraignment.
All rise. back in session, the Honorable Thomas R. Evans presiding.
Good afternoon, you may be seated, recalling the case Eagle versus Garrett Norman Grigg, file 20-010567-FC, with counsel identified for the record, please.
Good afternoon, Your Honor. Norman E. Gage appearing on behalf of the prosecutor's office.
Thank you, Your Honor. Andrew Santini on behalf of Mr. Gregg.
Today was the date and time scheduled for an arraignment in this matter, or how are we proceeding in that regard?
Your Honor, after having some time to talk with my client, we are going to be entering a plea at this point in time.
Okay,
And waiving any formal arraignment.
thank you, sir. Mr. Grigg, would you please stand and raise your right hand if you sworn, sir?
I
You
swear.
solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I swear.
Could you tell us your name, sir?
Garrett Grigg.
Mr. Grigg, have you discussed with your lawyer the information charging you with count 1 obstruction of justice?
Yes.
Do you want me to read that information to you for some reason?
No.
Do you want to have a preliminary examination?
No.
Do you understand, sir, that according to count 1, you are charged with the crime commonly known as obstruction of justice?
Yes, sir.
Now, that crime is a felony and it carries a maximum penalty of 5 years in prison and/or a fine of up to $10,000. And the minimum sentence is discretionary with the court. Do you understand those things, sir?
Yes.
You may make any one of the following 3 pleas to count 1 obstruction of justice. First, you may plead guilty if you are guilty, but don't plead guilty unless you are guilty. Second, you may plead not guilty. And third, you may stand mute and say nothing, in which event the court would enter a plea of not guilty for you. Do you understand the 3 possible pleas you may make to count 1 obstruction of justice?
Can I make a no contest plea going with my guilt?
Was that being offered by the people or not?
It wasn't.
No, you may not. You may plead either guilty if you are guilty, but don't plead guilty unless you are guilty. Or you may plead we're gonna back up. The 3 possible pleas you may make are as follows. First, you may plead guilty if you are guilty, but don't plead guilty unless you are guilty. Second, you may plead not guilty. And third, you may stand mute and say nothing, in which event the court would enter a plea of not guilty for you. Do you understand the 3 possible pleas you may make?
Yeah, I plead guilty.
Then first, do you understand the 3 possible pleas, Mr. Grigg?
Yes, sir.
Second, answering then to count 1 obstruction of justice, what is your plea?
Guilty.
Now, sir, do you understand that no one can make any promises for me about what your sentence will be?
Yes, Your Honor.
The court also informs you that if your plea of guilty is accepted, then that means you won't have a trial of any kind, and you therefore would be giving up each and every one of the following rights. The right to have a trial by a jury, the right to have a trial by a judge sitting without a jury if you prefer, the right to be presumed innocent until proven guilty, the right to require that the prosecutor prove you guilty beyond a reasonable doubt, the right to have all of the witnesses against you to appear at the trial, and for you and your lawyer to have the chance to question and cross-examine those witnesses, the right to have this court order any witnesses you might want for your defense to be required to appear at the trial, the right to remain silent during the trial and to not have your silence used against you. But finally, you also do have the right to testify at the trial, and if you choose to testify, then your testimony will be considered in the same manner as the testimony of any other witness. Do you understand all of these rights, Mr. Drake?
Yes, I understand.
Do you understand that by pleading guilty to count one, that means you will be giving up each and every one of these rights?
Yes, Your Honor.
Now, I'm going to ask your lawyer, Mr. Santini, and the Chief Assistant Prosecuting Attorney, Mr. Gage, to tell us what the plea agreement is, and I want you to listen to both of them very carefully. Mr. Gage, what is the plea agreement?
Your Honor, in the plea for the defendant's guilty plea to count one obstruction of justice, upon the court's acceptance of that plea, pronouncing sentence and running of the appropriate appeals period, the remaining count, that being the visual fourth notice, would be dismissed. Sentencing would take place with the guideline, and the initial sentence would not exceed 12 months. The defendant would be responsible for restitution if there is any, is found appropriate by the court.
Mr. Santini, is that your full and complete understanding of the plea agreement?
It is, Your Honor.
Mr. Grigg, did you hear what your lawyer and the Chief Assistant Prosecutor said the plea agreement is?
Yes, Your Honor, I did.
Did you understand the plea agreement?
Yes, I do.
And do you agree with it, sir?
I do.
Has anyone promised you anything beyond what is in that plea agreement to get you to plead guilty to count one?
No, just that agreement.
So, for example, has anyone promised you that if you pled guilty, that this court then would be lenient or light on you in any way?
No.
Has anyone threatened you or your family to get you to plead guilty?
No.
Is it your own personal choice to plead guilty, and are you doing so freely and voluntarily?
Yes, it is.
Do you have any questions about what the court has told you?
I do not.
Do you understand everything that the court has told you?
I do.
In light of everything that the court has told you, do you still want to plead guilty to count one, obstruction of justice?
Yes.
And sir, drawing your attention back to February 27 of 2020, were you in Buckeye Township in Gladwin County, Michigan?
Yes.
On that day and at that time, did you come into contact with a police officer?
Yes, I did.
Did this happen during a traffic stop or some other way?
A traffic stop.
And were you driving the vehicle, or were you a passenger in the vehicle, or what?
I was a passenger.
And during the course of this traffic stop, did the police officer pull over the vehicle that you were in?
Yep.
And was it a man or a woman officer?
A male.
And he was in his uniform, is that correct?
Yes.
And he was driving a marked patrol car?
Yes.
And he turned on the flashing lights to get the driver of the vehicle you were in to pull over, is that true?
After it was pulled over, it is.
Okay, so he pulled over the vehicle, then he turned on the flashing lights, is that correct?
Yeah, sure.
And And the officer, when he was doing these things, was acting in the lawful performance of his duties. Is that true?
Yes.
And you knew he was a police officer at that time, is that correct?
Yes.
And during the course of this traffic stop, did he ask you to identify yourself?
Yes.
Did you tell him your actual name, or did you somehow mislead him into thinking you were someone else?
I lied and then I actually told him my name.
So initially, you lied to him and told him a name other than Garrett Norman Grigg?
Yes.
And is the reason that you lied to the police officer because there was a warrant for your arrest in your actual name of Garrett Norman Grigg?
No.
Okay, why is it that you lied to the police officer?
Because I was scared for my life.
Well, how many times do police officers around here go around killing people because their last name is Grigg?
That's not why I was scared of my life.
All right. Why were you scared for your life, sir?
Because I will have to testify on a murder trial and there's people after me for that.
All right, so you knew that you were supposed to be a witness in a murder trial, is that correct?
Yes, it is.
And you knew that there was some sort of court order for you to be taken into custody so that you could testify at this trial, is that true?
Yes.
And so, is it true that by lying to the police officer, you were seeking to evade the execution of this lawful process of the warrant for you to be taken into custody?
Yep.
Are you satisfied, Mr. Santini, that there's a sufficient factual basis to accept the plea of guilty to count one obstruction of justice?
I am, Your Honor.
Do you agree, Mr. Gage?
I do.
Mr. Santini, has the court complied with the court rule in the taking of the plea?
Yes, Your Honor.
Do you agree, Mr. Gage?
Yes.
Very well, in this case, the court has not agreed upon the possible plea or the possible sentence with the prosecutor, the defendant, the defense attorney, or anyone else. The court is convinced that the plea is accurate and has been understandingly, knowingly, and voluntarily made. The plea of guilty to count one obstruction of justice is accepted in order to enter on the records of the court. Sentencing will occur at 2:20 p.m. on Monday, November 23rd, 2020. Bond is canceled and the case is adjourned to the date and time scheduled. But before you leave, Mr. Gray, I'm going to turn matters over to the probation agent, Mr. Brady. He might have some questions or directions for you.
Hi, Mr. Gregg. My name's Greg Brady, Gladden County Probation. I'm going to be sending you some information to fill out, and I'll schedule a time with your counselor to talk with you on the phone, okay?
Okay, when you send the stuff to fill out, can you send a reply stamp so that I can send it back to you?
I'll send.
Following the case of People versus Dean Christopher Muma, file 20-010545-FH, would counsel identify for the record, please?
Good afternoon, Your Honor. Norman E. Gage, appearing on behalf of the prosecutor's office.
Good afternoon, Your Honor. May it please this honorable court, Brian Jean, on behalf of the defendant, Dane Muma, who is present in my office this afternoon.
Thank you, Mr. Muma. Would you please stand and raise your right hand to be sworn, sir?
Do you solemnly swear testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Could you tell us your name, sir?
Christopher Muma.
Did you say Dane Christopher Muma?
That is correct, Your Honor.
You may be seated, sir. Today is the date and time scheduled for a pretrial conference in this matter. Are we proceeding, Mr. Jean, by way of a pretrial conference or by way of a plea?
Your Honor, by way of pretrial conference, this matter has actually a few other cases that are kind of tracking along with this one. There was a divorce that was filed as well as a PPO that was filed. The divorce, actually, we signed the dismissal forms for that divorce earlier, well, actually, it was actually late last week. My understanding is that the victim in this matter, Stacy Muma, who is my client's wife, has already petitioned for termination of the PPO, although we do have the motion date for the termination of the PPO coming up that we filed as well. So I don't know the status of whether or not that is still pending. Point being is that my understanding at this point is that Mrs. Muma is not wanting to proceed, although obviously I don't have any contact with her.
What is the significance of that, Mr. G?
To make sure that...
The case is the people of the state of Michigan versus Dean Christopher Muma, not Stacy Muma versus Christopher Dean Muma, or Dean Christopher Muma, pardon me. But in any event, you've indicated that it's your belief that perhaps the putative victim in this case, left to her own choices or devices, might want the case to be dropped, although I don't know what bearing, if any, that would have on the prosecutor's decision. But in any event, go ahead.
Well, that really was all I wanted to make sure that was communicated to the court, Your Honor. Obviously, I'm very well aware, as is my client, that Mrs. Muma does not have the authority to proceed or drop the case on her own. But certainly, I guess I wanted to make sure that Mr. Gage was also aware of the potential of that being the case if there were to be any follow-up. So to that end, we certainly would want to continue to proceed with the pretrial. And then if there are any issues later on, obviously we can file motions on those if necessary.
Okay, thank you, sir. Would you like the case scheduled for a bench trial or a jury trial?
We would like it to remain on the jury trial calendar, Your Honor.
Okay, and how many days do you think the trial would take, Mr. Gage?
I would estimate 1.5 to 2 days, Your Honor.
Does that sound, do you agree with that, Mr. G?
I do, Your Honor, yes.
All right. Are there any pretrial motions that people want to file, Mr. Gage?
Not at this point, Your Honor. It asks the court to allow 28 days from filing the preliminary exam transfer potential motions.
Okay, is that acceptable to you, Mr. G?
It is, Your Honor.
Thank you, sir. Is there anything else you would like included in the pretrial summary form, Mr. Gage?
No, Your Honor.
Or you, Mr. G?
No, Your Honor, not as far as the pretrial form.
Thank you. Mr. Gage, is there any issue as to bond?
No, Your Honor.
Very well, bond will be continued. The case will proceed to trial or other disposition. But Mr. Jean, was there something else you wanted to address today?
Your Honor, just if, very briefly, as it relates to bond, I understand there is no contact order. I guess I would request if we are able to get an agreement on the modification of the bond, if the court would be okay with a submission of a stipulation.
If the parties provide a stipulation and a proposed amendment to the bond, the court will consider that. And if I don't find it to be acceptable, I'll let each of you know, and you may file whatever motions you would like at that point.
Okay, thank you so much, Your Honor.
Thank you, Mr. Jean. Thank you, Mr. Muehlman. Thank you, Mr. Gage.
Thank you, Your Honor. Thanks, Brian.
Thank you.
Thank you.
But I'll let in just a second for you.
Okay.
There he is.
Calling the case of People versus Jonathan Keith Bierbauer, file 20-010566-FC. Would counsel identify for the record, please?
Good afternoon, Your Honor. Norman E. Gage, on behalf of the prosecutor's office.
And appearing on behalf of the defendant.
Muted.
How about now?
Good.
Can you
Appearing
hear
on
me?
behalf of the defendant, Mr. Bierbauer, is.
Matthew Reyes with Mr. Bierbauer.
Thank you. The record should reflect this case is, or this matter is being held via Zoom, and that is pursuant to Michigan Supreme Court Administrative Order 2020-9. Both the Chief Assistant Prosecuting Attorney, Mr. Gage, and I are physically present here in the courtroom in Gladwin, Michigan. The defendant and defense attorney are present, participating. They are present at the office of Attorney Matt Reyes in Bay City, Michigan, participating via Zoom. Is that procedure acceptable to you, Mr. Gage?
It is, Your Honor.
And to you, Mr. Reyes?
Yes, sir.
And today is the date and time scheduled for a pretrial conference. Are we proceeding by way of pretrial conference or by way of plea?
Your Honor, I've been dealing with, obviously, Mr. Miller on this file. I guess I'm not sure what Mr. Gage is aware of. I know we had talked about amending our discussed plea agreement. I don't know whether that has been done. I haven't received an additional information, so I guess I'm just not sure.
If I may, Mr. Reyes, Mr. Miller has wrote up a pretrial, or excuse me, a plea agreement that includes an amended count 3, attempt assault with intent to do great bodily harm, less than murder, a 5-year charge, and he wrote it up with no objections to HYTA. I'm not sure what conversations were that you and Mr. Miller had. I know he had talked a little bit about foolish assault, but neither of you could come up with an appropriate weapon, so this became an alternative to accomplish what you and Mr. Miller were attempting to accomplish through a plea.
That is correct. And with that, with the knowledge of that plea agreement having been authored, we're ready to proceed by way of a plea.
Okay, and this would have, if the defendant wishes to have the option of at least of the Youthful Trainee Act status, it would have to be a guilty plea, and presumably the basis for the guilty plea would be to establish a basis for either count 1, criminal sexual conduct of the first degree relationship, or count 2, criminal sexual conduct of the third degree incest. And I only bring that to your attention, Mr. Reyes, because I would prefer not to get halfway through the plea-taking process and run into a snag as far as establishing a factual basis for a guilty plea. Do you foresee that being a problem, Mr. Reyes?
Judge, my only concern is Mr. Miller and I, in our plea discussions and in our coming up with this resolution, we have also, we've done this for purposes of A, being eligible for HIDA, and also putting us in a position where Mr. Bierbauer would not be placed on the sex offender registration list. And I mean, I know that the catch-all provisions of the sex offender registration list can get a little tricky in terms of what the recommendations from the department will be. And, you know, what I want to avoid is getting through the plea process, getting to sentencing, and then, you know, being in a position where, you know, that further negotiation part of not being on the sex offender registration list becomes an issue again. That's my only concern.
All right, you want to go ahead?
If I may. Mr. Reyes, when you and Mr. Miller were talking, did the registry come up as part of the conversation?
Yes, in fact, that was one of the huge motivating factors for proceeding in this manner.
So if I stipulate that the prosecutor's office will not pursue registry on the catch-all basis, does that put you at ease?
Absolutely.
Done.
All right. Mr. Bierbauer, would you please stand and raise your right hand to be sworn, sir?
Stand up and raise your right hand. Stand up.
Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Could you speak up, sir?
Yes.
Could you tell us your name?
Jonathan Keith Bierbauer.
You may be seated, Mr. Bierbauer. Are we proceeding on count one then, Mr. Reyes?
I guess, Your Honor, based on the facts, it doesn't matter, count one or count three. We can proceed on count one. It's gonna, the facts will allege a sexual intercourse by people who are related when they were statutorily unable to consent. So the facts are the same for 1 and 3.
Okay, thank you, Mr. Reyes. Mr. Bierbauer, and we'll proceed on count two, criminal sexual conduct, or CSC, third degree. If that's acceptable to you, Mr. Reyes?
Yes, sir.
And is it to you, Mr. Gage?
It is, Your Honor.
Very well, Mr. Bierbauer, drawing your attention back to the time period, the 3-year time period from July 22nd of 2017 through July 17 of 2020, were you in Tobacco Township in Gladwin County, Michigan?
Yes.
Yes.
And during that time, did you engage in sexual intercourse with a girl who was at least 13 years of age but younger than 16, sir?
Yes.
And was this girl related to you in some fashion?
Yes.
How was she related to you?
My sister.
And so when this activity started in July of 2017, how old was your sister at that time?
14.
And when it ended in July, on or about July 17 of 2020, how old was she?
16.
All right, do you know what her birthday is or not?
October 4th.
So was she born October 4 of 1994 then?
2003, Your Honor.
Or of 2003, I'm sorry. Thank you, Mr. Gage.
Yes.
So, October 4 of 2003. And so these events, do you want me to amend the information to read on or about July 22nd, 2017 through on or about October 3rd of 2019, which would be the day before the 16th birthday, I believe?
That would be fine, Your Honor.
Any objection, Mr. Reyes?
No, Your Honor.
Very well, the court will make that amendment on the record so that the date of offense is on or about July 22nd, 2017 through on or about October 3rd, 2019. So, sir, drawing your attention to the time period from July 22nd, 2017 to October 3rd of 2019, were you in Tobacco Township in Gladwin County, Michigan?
Yes.
And during that time period, your sister then was 14 years of age all the way up to 15 years and 364 days.
Yes.
So she was 14 or 15 years old during this time period, is that correct?
Yes.
And during this time period, did you engage in sexual intercourse with your sister?
Yes.
And did that involve you inserting your penis into her vagina?
Yes.
All right, and what is your date of birth, sir, October 31 of 2002?
Yes.
So at least from October 31 of 2018 through October 3rd of 2019, well, I won't ask that question. Your date of birth is October 31 of 2002, correct?
Yes.
Are you satisfied, Mr. Reyes, that there's a sufficient factual basis to accept the plea of guilty to count 2, criminal sexual conduct in the 3rd degree incest?
Yes, sir.
And do you agree, Mr. Gage?
I do, Your Honor. By doing it that way, the court can accept the plea to the amended count under the waived court rule.
Thank you, and I had thank you, sir. I think I've messed up this plea in some regards, so we will back up, and Mr. Bierbauer, have you discussed with your lawyer? I'm going to set aside the plea to count 2, and proceeding on count 3 and using as a factual basis for the plea to count 3, perhaps a factual basis for count 2. Mr. Bierbauer, do you understand, sir, that according to count 3, you are being charged with the 5-year felony crime commonly known as attempted, wait a minute, about to botch this whole thing again.
If I may, Your Honor, it's attempt to assault with intent to cause great bodily harm less than murder.
All right. Mr. Bierbauer, have you received and talked with your lawyer about the added count 3 of the amended information charging you with attempted assault with intent to do great bodily harm less than murder?
Yes.
Do you want me to read that amended information to you, Mr. Bierbauer?
We would waive the reading, Your Honor. We've discussed it at length. Mr. Bierbauer's aware of the charge and the possible penalties.
Thank you, sir. Do you want to have a preliminary examination, Mr. Bierbauer?
No.
Mr. Bierbauer, do you understand that according to count 3, you are being charged with assault with intent to do great bodily harm less than murder? You
Yes.
understand that? Now, that crime is a felony and it carries a maximum penalty of 5 years in prison, and the minimum sentence would be discretionary with the court. Do you understand those things?
Yes.
Now, with regard to count 3, you may make any one of the following 3 pleas. First, you may plead guilty if you are guilty, but don't plead guilty unless you are guilty. Second, you may plead not guilty. And third, you may stand mute and say nothing, in which event the court would enter a plea of not guilty for you. Do you understand the 3 possible pleas you may make to count 3? Attempted assault with intent to do great bodily harm less than murder.
Yes.
Then answering to count 3, what is your plea?
Guilty.
Now, Mr. Bierbauer, do you understand that no one can make any promises for me about what your sentence will be?
Yes.
The court also informs you that if your plea of guilty is accepted, then that means you won't have a trial of any kind, and you therefore would be giving up each and every one of the following rights. The right to have a trial by a jury, the right to have a trial by a judge sitting without a jury if you prefer, the right to be presumed innocent until proven guilty, the right to require that the prosecutor prove you guilty beyond a reasonable doubt, the right to have all of the witnesses against you to appear at the trial, and for you and your lawyer to have the chance to question and cross-examine those witnesses, the right to have this court order any witnesses that you might want for your defense to be required to appear at the trial, the right to remain silent during the trial and to not have your silence used against you. But on the other hand, you also do have the right to testify on your own behalf at the trial. And if you choose to do so, then your testimony will be considered in the same manner as the testimony of any other witness. Do you understand all of these rights, sir?
Yes.
And do you understand that by pleading guilty, that means you'll be giving up each and every one of these rights?
Yes.
Now, Mr. Bierbauer, I'm going to ask your lawyer, Mr. Reyes, and the Chief Assistant Prosecuting Attorney, Mr. Gage, to tell us what the plea agreement is. And I want you to listen to both of them very carefully. Mr. Gage, what is the plea agreement?
Your Honor, in return for the defendant's guilty plea to the amended count 3, attempted assault with intent to cause great bodily harm less than murder, people would be dismissing the remaining counts once the court has accepted that plea, pronounces this, and running the appropriate appeals agreement. The people have objections to the defendant petition for consideration under the Home Lethal Trainee Act, the people will not pursue registration registry using the catch-all basis or the other portion of that statute.
Mr. Reyes, is that your full and complete understanding of the plea agreement?
It is, sir, yes.
Mr. Bierbauer, did you hear what the prosecutor and your lawyer said the plea agreement is?
Yes.
Did you understand the plea agreement?
Yes.
And do you agree with it?
Yes.
Has anyone promised you anything beyond what is in that plea agreement to get you to plead guilty?
No.
For example, has anyone promised you that if you pled guilty that this court then would be lenient or light on you in any way?
No.
Has anyone threatened you or your family to get you to plead guilty?
No.
Is it your own personal choice to plead guilty, and are you doing so freely and voluntarily?
Yes.
Do you have any questions about what the court has told you?
You have any questions?
No.
And do you understand everything that the court has told you?
Yes.
And in light of everything that the court has told you, do you still want to plead guilty to count 3, attempted assault with intent to do great bodily harm less than murder?
Yes.
Very well then, sir, drawing your attention back to July 22nd of 2017 through October 3rd of 2020, were you in Tobacco Township in Gladwin County, Michigan?
Yes. Yes.
Yes.
Okay, on those dates and at that location, did you engage in sexual intercourse with your sister?
Yes.
And did that sexual intercourse include you inserting your penis into her vagina?
Yes.
And your sister's date of birth, the one with whom you were having the intercourse, was her date of birth October 4 of 2004?
2003.
Thank you, sir. So October 4 of 2003 is when your sister, the victim of this alleged crime, that's when she was born?
Yes.
And I called her your sister. Do you, is she your full sister? Your sister, your biological sister?
Yes.
And Mr. Reyes, are you satisfied there's a sufficient factual basis to establish a plea of, to establish guilt to count 2, criminal sexual conduct or CSC in the 3rd degree incest, and therefore, to accept the plea of guilty on that basis to count 3, attempted assault with intent to do great bodily harm less than murder?
Yes, I am.
Are you satisfied as well, Mr. Gage?
I am, Your Honor.
Mr. Reyes, has the court complied with the court rule of the taking of the plea?
Yes, sir.
Do you agree, Mr. Gage?
The court has, Your Honor.
Very well, in this case, the court has not agreed upon possible plea, possible sentence with the prosecutor, the defendant, the defense attorney, or anyone else. The court is convinced that the plea is accurate, has been understandingly, knowingly, and voluntarily made. The plea of guilty to count 3, attempted assault with intent to do great bodily harm less than murder, is accepted and ordered entered on the records of the court pursuant to the Holmes Youthful Trainee Act. So it's accepted conditionally and ordered entered on the records of the court. Sentencing and or disposition pursuant to the Youthful Trainee Act will occur at 2:40 p.m. on Monday, November 23rd, 2020. Is there any issue as to bond, Mr. Gage?
Oh, Your Honor.
Very well. I'm going to continue the bond then. And when you come back, Mr. Bierbauer, you could be put in prison for up to 5 years, or you could be put in the county jail for up to a year, or something else might happen. One thing that will happen is you'll be ordered to pay some court-ordered money that will add up to about $2,000. So you have another month now to take legal steps to raise that money and have it available when you return to be sentenced. Mr. Reyes, is there any problem with us conducting the sentencing in person on that day? That would be my preference.
I don't believe so, Your Honor, no.
All right, so we'll plan on, rather than having a Zoom hearing, we'll plan on the prosecutor, the defendant, and defense attorney appearing in person at 2:40 p.m. on Monday, November 23rd. But before we leave, Mr. Bierbauer, I'm going to turn matters over to the probation agent, and he will give you some instructions so that he'll be able to prepare a report for the sentencing. The minimum sentence would be discretionary with the court. You understand that? And unless the court were to sentence you to more than 1 year in prison, the court also must suspend or revoke your driver's license. You understand those things?
Yes, sir.
Now, turning to file 20-10592-FH, do you understand that in count 2, you are charged with delivery or possession with intent to deliver hydromorphone, the controlled substance hydromorphone? You understand that?
Yes, sir.
Now, that crime is a felony, and it carries a maximum penalty of 7 years in prison and or a fine of $10,000, and the minimum sentence is discretionary with the court. You understand that?
Yes, sir.
Once again, unless the court sentences you to more than 1 year in prison, the court must suspend or revoke your driver's license. You understand that?
Yes, sir.
Then turning to file 20-10591-FH, do you understand, sir, that according to count 2, you are charged with possession of methamphetamine, second or subsequent offense notice, under the Michigan Controlled Substance Act?
Yes, sir.
Now, possession of methamphetamine is a felony and normally would carry a maximum penalty of 10 years in prison and or a fine of up to $15,000. However, when coupled with the second or subsequent offense notice for having previously been convicted of a controlled substance offense under the Michigan Controlled Substance Act, the net effect of that is that the court in its discretion may double the maximum penalty from 10 years in prison and/or a $15,000 fine to 20 years in prison and/or up to a $30,000 fine. Do you understand all those things?
Yes, sir.
And in each of these cases, the minimum end of the sentence would be discretionary with the court. Do you understand all those things, sir?
Yes, sir.
Now, with regard to count 2, in each one of these 3 separate files, you may make any of the following 3 pleas. First, you may plead guilty if you are guilty, but don't plead guilty unless you are guilty. Second, you may plead not guilty. And third, you may stand mute and say nothing, in which event the court would enter a plea of not guilty for you. Do you understand the 3 possible pleas that you may make to count 2 in each of these 3 files?
Yes, sir.
Then starting with file 20-10589-FH, answering to count 2 in that file, what is your plea?
I didn't realize I was having to plead guilty or not today. I didn't even
Well,
talk to my
I
lawyer.
guess maybe we've wasted perhaps the last 10 minutes, and maybe we should take a break, let you confer with your lawyer, and let you decide at long last what it is you'd like to do today, and then we'll proceed. We'll be in recess for a little bit.
All right. Back in session, the Honorable Commissar Evans presiding.
Good afternoon. You may be seated, recalling the case of People versus Bruce William Garrett, file numbers 20-10589-FH and 20-10592-FH and 20-10591-FH. Mr. Garrett, you still are under oath. Do you understand, sir, that with regard to count 2, in each one of these 3 files, you may make any one of the following 3 pleas? First, you may plead guilty if you are guilty, but don't plead guilty unless you are guilty. Second, you may plead not guilty. And third, you may stand mute and say nothing, in which event the court would enter a plea of not guilty for you. Do you understand the 3 possible pleas you may make to count 2 in each of these 3 files, Mr. Garrett?
Yes, sir.
And starting with file 20-10589-FH, answering to count 2 in that file, possession of less than 25 grams of fentanyl, second or subsequent offense notice under the Michigan Controlled Substance Act. What is your plea?
Guilty.
Turning to file 20-10592-FH, answering to count 2 in that file, delivery or possession with intent to delivery of less than, answering to count 2 in that file, delivery or possession with intent to deliver the controlled substance hydromorphone. What is your plea?
Guilty.
And turning to file 20-10591-FH, answering to count 2, possession of methamphetamine, second or subsequent offense notice under the Michigan Controlled Controlled Substance Act, what is your plea?
Guilty.
Now, sir, do you understand that no one can make any promises for me about what your sentence will be?
Yes, sir.
The court also informs you that if your pleas of guilty are accepted in these 3 files, then that means you won't have a trial of any kind in any of the 3 files, and you therefore would be giving up each and every one of the following rights in all 3 files. The right to have a trial by a jury, the right to have a trial by a judge without a jury if you prefer, the right to be presumed innocent until proven guilty, the right to require that the prosecutor prove you guilty beyond a reasonable doubt, the right to have all of the witnesses against you to appear at the trial, and for you and your lawyer to have the chance to question and cross-examine each of those witnesses, the right to have this court order any witnesses that you might want for your defense to appear at the trial, the right to remain silent during the trial and to not have your silence used against you. But finally, you also do have the right to testify at the trial, and if you choose to do so, then your testimony would be considered in the same manner as the testimony of any other witness. Now, do you understand all of these rights, Mr. Garrett?
Yes, sir.
And do you understand, sir, that by pleading guilty to count 2 in each one of these 3 files, that means you'll be giving up each and every one of those rights in all 3 of these files?
Yes, sir.
Now, sir, I'm going to ask your lawyer, Mr. Dietrich, and the Chief Assistant Prosecuting Attorney, Mr. Gage, to tell us what the plea agreement is, and I ask you to listen to each of them very carefully. Mr. Gage, what is the plea agreement?
Your Honor, starting with file 20-10589FH, it is my understanding that the defendant will be entering a guilty plea to count 2, possession of fentanyl, second or subsequent offense. In file 20-10591FH, the defendant will be entering a guilty plea to count 2, possession of methamphetamine, the second or subsequent offense. And in file 20-10592, the defendant will be pleading guilty to the amended count 2, controlled substance delivery of hydromorphine, with the remaining counts in all those files being dismissed, as well as file 20-10590FH in its entirety. Further, Your Honor, the defendant would pay restitution as found appropriate by the court in all of these matters, if in fact there is any restitution. And Your Honor, there is a sentencing agreement whereby the defendant would be sentenced within the guidelines, and in no event would the initial incarceration exceed 12 months. Further, Your Honor, as part of the sentencing agreement, the defendant would be allowed to petition the court to allow him to attend rehab, inpatient rehab, after serving the initial 8 months of any period of incarceration imposed.
Mr. Dietrich, is that your full and complete understanding of the plea agreement?
It is, Your Honor.
Mr. Garrett, did you hear what the prosecutor and your lawyer said the plea agreement is in these 3 cases?
Yes, sir.
Did you understand the plea agreement?
Yes, sir.
Do you agree with it?
Yes, sir.
Now, has anyone promised you anything beyond what is in that plea agreement to get you to plead guilty to count 2 in each of these 3 files?
No, sir.
So, for example, has anyone promised you that if you pled guilty, that this court then would be lenient or light on you in any way, Mr. Garrett?
No, sir.
Has anyone threatened you or your family to get you to plead guilty?
No, sir.
Is it your own personal choice to plead guilty, and are you doing so freely and voluntarily?
Yes, sir.
Do you have any questions about what the court has told you?
No, sir.
Do you understand everything that the court has told you?
Yes, sir.
In light of everything that the court has told you, do you still wish to plead guilty to count 2 in each of these 3 files?
Yes, sir.
Then starting with file 20-010589-FH, drawing your attention back to on or about December 23rd of 2019, were you in the city of Gladwin in Gladwin County, Michigan?
Yes, sir.
On that day and at that location, did you have some fentanyl in your possession?
Yes, sir.
And the substance that you had, was there, the fentanyl that you had, was there more than 25 grams of it or less than 25 grams?
Less than?
And you knew that this substance was fentanyl at the time you possessed it?
Yes, sir.
Did you have any legal right or justification or mitigation to possess the fentanyl back in December of last year?
No, sir.
And sir, drawing your attention to on or about April 17 of the year 2000, were you convicted of possession of marijuana here in Michigan?
Yes, sir.
And drawing your attention to on or about July 26th of 2012, were you convicted of the crime of use of a controlled substance here in Michigan as well?
Yes, sir.
With regard to that particular file, 20-010589-FH, are you satisfied, Mr. Dietrich, that there's a sufficient factual basis to accept the plea of guilty to count 2?
Yes, Your Honor.
And do you agree, Mr. Gage?
I do, Your Honor.
And Mr. Dietrich, has the court complied with the court rule of the taking of the plea in that file?
Yes, Your Honor.
Do you agree, Mr. Gage?
The court has, Your Honor.
Turning to file 20-010592-FH, and turning to count 2 in that file, Mr. Garrett, drawing your attention back to the time period from on or about October 1 of 2019 through on or about December 18 of 2019, were you in the city of Beaverton in Gladwin County, Michigan?
Yes, sir.
During that time period and at that location, did you possess hydromorphone with the intent to deliver it to another person?
Yes, sir.
Did you have any legal right or justification or mitigation to possess the hydromorphone?
No, sir.
Did you have any legal right or justification or mitigation to deliver the hydromorphone to another person?
No, sir.
Did you in fact deliver the hydromorphone to someone else during
Yes, sir.
that time period? Are you satisfied, Mr. Dietrich, that there's a sufficient factual basis to accept the defendant's plea of guilty to count 2 in file 20-010592-FH?
Yes, Your Honor.
Do you agree, Mr. Gage?
Yes, Your Honor.
And has the court complied with the court rule of the taking of that plea, Mr. Gage? I'm sorry, Mr. Dietrich.
Yes, Your Honor.
Do you agree, Mr. Gage?
I do, Your Honor.
Turning to file 20-010591-FH, and turning to count 2 in that file, Mr. Garrett, drawing your attention back to March 10 of 2020, were you in Buckeye Township in Gladwin County, Michigan?
Yes, sir.
On that day and at that location, did you possess some methamphetamine?
Yes, sir.
Did you know the substance you possessed at that time was
Yes, sir.
methamphetamine? Did you have any legal right or justification or mitigation to possess the methamphetamine?
No, sir.
And drawing your attention to July 26th of 2012, were you convicted in the state of Michigan of the crime of use of a controlled substance?
I'm sorry, what was that?
Drawing your attention back about 8 years ago to July 26th of 2012, were you convicted here in Michigan of the crime of use of a controlled substance?
Yes, sir.
Are you satisfied, Mr. Dietrich, that there's a sufficient factual basis to accept the plea of guilty to count 2 in that file?
Yes, Your Honor.
Do you agree, Mr. Gage?
I do, Your Honor.
Mr. Dietrich, has the court complied with the court rule in the taking of the plea in all 3 of these files?
Yes, Your Honor.
Do you agree, Mr. Gage?
The court has complied, Your Honor.
Very well, in this case, the court has not agreed upon the plea or the sentence in any of these cases. The court has not agreed upon possible plea or possible sentence in any of these 3 cases. The court is convinced that each of the 3 pleas is accurate and has been understandingly, knowingly, and voluntarily made. The pleas of guilty to count 2 in each one of these 3 files are accepted and ordered entered on the records of the court. Sentencing will occur at 2:40 p.m. on Monday, November 23rd, 2020. The bond is canceled in all 4 cases, and we'll proceed to sentencing at that date and time. But before we leave, Mr. Garrett, the probation agent has some instructions to give to you, sir.
Mr. Garrett, what jail are you currently in?
Gladwin County Jail.
Very well, I'll be dropping some papers off in the next few days for you to fill out, okay?
Okay, thank you.